All right. I think we'll get started. I want to welcome everyone to our final session of Institute for Governmental Studies Race, Ethnicity, and Immigration workshop, or colloquium, I should say. I think we've had a really strong semester, and I think we're also we're going to end on a really high note as well. Some of you folks know my name is Michael Rodriguez, Associate Professor in the Department of Sociology. I'm Puerto Rican. That's probably why the last 2 years have had a bit more Puerto Rican programming in this colloquium. I do not apologize for that. So it comes with me. So today is the colloquium is sponsored by Institute for Governmental Studies, but we're also have support from the Center for Race and Gender, as well as the newly formed Anti-Colonial Democracy Lab that myself and a couple colleagues in sociology and Black studies are coordinating. I want to thank IGS, Christina Mora, for their support of this colloquium, and also Ezra, Mary, and Dawn for a lot of the logistical work that makes this possible. So very grateful for that. Next spring, we're going to have a series of talks as well. I don't think I've squeezed in a Puerto Rico one in the spring, but there will be a lot of interesting topics from immigration to issues about race and space, among other things. So I want to introduce our guest. I don't know if Monica Jimenez was going to mention this, but this is November 19th, which is the Day of Discovery in Puerto Rico. So the start of colonialism, and so we'll be talking about those things. We'll be hearing about that. So let me tell you a little bit about Monica Jimenez. Professor Jimenez is an assistant professor in African and African diaspora studies at the University of Texas, Austin. She is a poet and historian whose work explores the intersections of law, race, and empire in Latin America and the Caribbean. Dr. Jimenez's innovative research has received support from various institutions. She's won various prestigious fellowships. One that I'll mention, that in 2021, she was named the inaugural Letras Boricuas Fellow by the Flamboyant Arts Foundation. Her scholarly and creative work has been published in outlets such as the Radical History Review, Latino Studies, Central Journal, and the WSQ Women's Studies Quarterly, among others, both scholarly and artistic and creative work. Today we're gonna learn and hear about Professor Jimenez's brand new book. The book just came out in June of this year, Making Never Neverland, Race and Law and the Creation of Puerto Rico, which is published by the University of North Carolina Press. So I'm very excited that we have an opportunity to hear from Professor Jimenez about this book, which I think is an important contribution to ongoing discussions about Puerto Rico and beyond. So with that, please join me in welcoming Professor Jimenez to Berkeley.
My many drinks with me. Thank you, Michael, for the invitation and for that lovely introduction. And thank you to you all for being here, and to the staff who have made this visit possible, organized the logistics of this room and of my trip. So thank you, everyone. It's exciting to be here. To speak with you about this book that, books are a labor of a long time. This certainly was. I want to start, it's funny because I went back and forth like, oh, how do I begin? But I'm going to start with a poem that was published about a year ago in a journal called the Poetry Project Newsletter, which is a kind of alternative, a little bit unconventional poetry journal. It's been around since the 60s. I think it was started by the Beat Poets in New York, so it's a little bit of a about a little over a year ago, a friend of mine approached me and said, would you contribute a poem to the special issue that she was, of the journal that she was editing about displacement and dispossession? So she was specifically asking poets of color to contribute poetry that sort of addressed that subject writ large. And I had this poem that I wrote probably 6 years before that. In 2016, I started to write it, and I think I finished it in 2017. So just, so we know how long these things sometimes take, right, before they materialize. And so I was like, yes, I have a poem. And she's like, great, will you annotate it? And I was like, yes, I will. And so this poem is called American State of Exception. And I want to read it because in many ways, this is the beginning of my thinking of the ideas that became this book. So American State of Exception. And I wish in the past I've actually shared the image of it so you can see the annotations, but I didn't do that this time because I wasn't sure I was going to read it. But so here it is. 1. Sovereignty here does not bear its ordinary meaning. Nevertheless, it desires the power to punish. There is no authority when one lives on an island of indistinction. Necessity knows no law for those with need. What is the solution to the problem of colonialism? More colonialism. 2, consider this juridical conundrum. If the public powers violate the rights of the people, resistance to oppression is the duty of the citizen. Benjamin witnesses in spirit, pondering our legacy of natural law as a form of violence. There are certain principles of natural justice inherent in our character that need no expression in constitutions. 3, law functions to eliminate entire categories of people that do not exist and so cannot be integrated into the political system. Those who may live or must die, whose lives can be subjected to the power of death. This is merely a question of legitimacy. Are you specifically authorized by the state to be a debtor? 4, justice finds that we are not of the political community brought into existence by our Constitution. This is the modern totalitarianism, a utopia devoid of law, a non-place where no violence is absolutely outside the law. There is no legal succession in empire because the non-human cannot contract or capitalize. Everything is for sale in the frontier. 5, citizenship appears to offer us something other than exclusion. Still, we must be raced and we must be dangerous. Or we must be raced and we must be pitiable. Either way, we must first exist as bodies in want of intervention. So what you can't see that the visual shows you is that many of these lines are actually taken from Supreme Court cases. So when I'm starting to think about this project, I'm sort of immersing myself in a whole series of Supreme Court decisions, some of them from the early 20th century, some of them much more contemporary, that are sort of speaking to each other in ways that at the time, I wasn't sure other people were sort of seeing in the way that I was seeing. So that was kind of the genesis of thinking about these ideas that finally lend themselves into this book. And so I finished my PhD in 2015. I had written about law in my dissertation, but in a very different way. And as that is happening, Puerto Rico is sort of making headlines for the debt crisis. And so I'm tracking the debt crisis and what's happening in Puerto Rico, as well as these Supreme Court cases that are making their way up to the court about Puerto Rico's debt crisis. And so in March of 2016, one of these decisions goes to oral argument at the Supreme Court. And rest in peace, RBG. Before her death, she's on the bench sort of quizzing about what these lawyers are arguing about Puerto Rico. And she says this: why would Congress put Puerto Rico in this never, never land? Why in the world? What explains Congress wanting to put Puerto Rico in this anomalous position? And so thank you, right? Because she gives me the title of my book. And I'm upfront about that now because many people ask me, where does this come from? Right? And if you read the book, it's actually in the 5th chapter. So you have to read the whole book to get to the answer, but I'll give you the answer now. So I am a year out of law school or out of grad school and thinking about law, and I read this in the transcript. And I had one of those moments where I look around like, is anyone else seeing this? Because I was like, surely she's not really asking this question, right? Because it wasn't Congress that did this, that made the Never Never Land. It was the Supreme Court on which she sat, right? So I was like, surely Justice, right? Honorable Justice Ruth Bader Ginsburg knows that it's not Congress who put Puerto Rico in Never Never Land, or it's not, it's not Congress, it was the Supreme Court in 1901. And so for me, that just sort of sparked like, oh, wow, 2016 is this like parallel moment to 1901. And how are we not talking about this, right? For me, it was like these bookend moments. So I'm watching this happen. In June of 2016, the decision in this case was handed down. 2-3 days later, a decision in another Supreme Court case about Puerto Rico was handed down. So within a week, there's 2 decisions about Puerto Rico, and I'll talk about them a little bit later. And then there's the sort of infamous promesa that gets passed, right? The Puerto Rico Oversight Management Economic Stability Act. It's a mouthful. That all happens within a week's time, basically. And so again, 2016 acting as this like radical moment of transformation for Puerto Rico. And I'm like, wow, this is looking and feeling a lot like 1901. And so that's kind of what sparked this. I was like, I have to think about it. I have to write about this. And it took me this long to really come to, right? Because ideas need time to gestate and to like grow. And it took all that time for me to really think about what was happening and how I saw that sort of functioning. And so, but ultimately though, right, as complicated as the law is and as the relationship is, the questions that I wanted to ask were pretty simple. What is Puerto Rico? What are Puerto Ricans to the US? And how did we get here, right? Fairly straightforward questions that, as we will see, have really complicated answers and are only more complicated by these decisions that the Supreme Court makes. And that Congress makes. And so that was really for me the kind of the kernel is like, I want to know the answer to these fairly simple questions, but what I'm coming against is that they actually have very convoluted answers. And they're only sort of made more convoluted by the ways that the Supreme Court has sort of approached Puerto Rico in the past. So my talk today is going to kind of give you an overview of the ideas and the historical trajectory that are highlighted in Making Never Never Land. I first examined Supreme Court precedents that serve as models for the court's 1901 decision. So that 1901 moment where the Supreme Court puts Puerto Rico in Never Never Land, that wasn't, spring from the head of Zeus type of thing, right? It has a long sort of what I call a legal genealogy of racial exclusion, right? Where the Supreme Court is sort of looking at its previous precedents of addressing Native American land rights and citizenship and African-American citizenship and rights, right? And from those legal precedents, it sort of derives its 1901 decision. And so the first half of the book is looking at that and really unpacking that history. And then the second half of the book is really thinking about, okay, now that we understand that, what does that look like in Puerto Rico? How has that impacted Puerto Rico in the 20th and 21st centuries? And obviously that could be a very big book, right? Because the history of native dispossession legal dispossession begins in 1823. And this book ends in 2022, right? So it could be a gigantic book. So what I chose to do to make it not be a gigantic, unwieldy book was to really be discreet about the moments in the 20th and 21st century that I'm looking at. And I focus on these moments where I see law operating in sort of heavy-handed ways, right? Where it's like things are being very impacted by the legacies of these early 20th century decisions. And that's how I kind of was able to wrap my head around this very long history. So what I want to do is I'm going to read sort of excerpts from the book and then contextualize them as a way of kind of moving through the book. And I'll try to, give you the highlights. Okay, so yes, make sure I'm on the right slide, because I tend to do the thing where I very carefully say, you should be on slide 2, and then I ignore all my notes to myself. And then I'm like, I don't know what slide I'm on. Okay. The steamer Ponce entered the port of New York carrying 576 boxes of oranges on November 20th, 1900. These oranges were the property of Samuel B. Downs, a merchant who was fast taking advantage of the commercial opportunities offered in Puerto Rico, the United States' newly acquired overseas territory. Upon arrival in New York, Downs's goods were intercepted and detained by George R. Bidwell, the collector of customs for the Port of New York. Bidwell designated the oranges foreign goods and levied $659 as import tax. Downs then sued in federal court, arguing that since Puerto Rico had been acquired by the United States in 1898, it had become a part of the US, and thus taxation of goods from the archipelago was unconstitutional. This completely banal event, the arrival of tropical fruit from Puerto Rico at a port of the United States and the levying of import duties on that fruit, led to the most important legal precedent in the history of the archipelago, and one that continues to define Puerto Rico's economic and political possibilities over a century later. The case of Downs v. Bidwell, among the first of the infamous Insular cases, which attempted to define the United States' legal relationship to its burgeoning overseas empire, was carefully followed by private business owners, legal scholars, politicians, the media, and the public at large. Downs and the other Insular cases quickly became a referendum on the United States' imperial designs at the start of the 20th century. The US Supreme Court, understanding the many interests at stake, attempted to toe a careful line in which it could allow the US government to hold on to the insular territories and reap the economic benefits available therein, while also not extending citizenship or too many rights to the territories or their inhabitants. I focus on Downs v. Bidwell from 1901 because it is there that the Supreme Court famously or infamously pronounced Puerto Rico to be, quote, foreign in a domestic sense, a nonsensical declaration that continues to flummox and confuse today. It was also in Downs that the court first declared Puerto Rico to be an unincorporated territory and set it on a course of legal exclusion that continues to define it today. The category of unincorporated territory, though novel at the time, had important precedents in the court's previous decisions dealing with Native and Black Americans. This moment of late 19th century imperial expansion forced the US to contend with the many mixed race inhabitants of its new territories. In the midst of Jim Crow segregation, the US government understood these subjects as decidedly not white and more Black than not. Thus, the US turned to its history with its other non-white subjects for guidance on what to do with the people inhabiting the insular territories. I connect Downs to the logics of the legal reasoning of the Marshall Trilogy and Dred Scott v. Sanford, not just because both are cited by the court in Downs v. Bidwell, but also because the Supreme Court in Downs engaged in a critical moment of racial formation. It relied on its previous precedents concerning racial undesirables to mark Puerto Rico as a racialized space and its inhabitants intelligible within the racial and legal logics of the US, right? So not that Puerto Rico wasn't already a racialized space, but that it did so within the ways that the US understood race to operate, which is decidedly different for how race operates in the Caribbean. This decision created Puerto Ricans as a racialized people and established the need to exclude them from the US polity. Within this legal genealogy, the Supreme Court carved out various states of exception, lacunae of law where the protections of the US Constitution do not apply or apply only in limited fashion, and where racial undesirables, like Native Americans, Black Americans, and the inhabitants of the insular territories, were left exposed to the whims and violence of the state. The court's decision in Downs created such a state of exception in Puerto Rico, wherein the US Constitution did not fully apply and wherein the archipelago was left exposed to the vagaries of Congress's plenary or complete power. Collectively, the Marshall Trilogy, Dred Scott, and Downs form but a part of a much larger legal genealogy of racial exclusion and help to illustrate how the court's reasoning, steeped in ideas of settler colonialism, anti-Blackness, and social Darwinism, underwent many contortions and legal gymnastics in order to create states of exception for racial others. And so this sort of idea of the state of exception, right? Many of us have studied it. And at the time I was really sort of intrigued by its sort of location outside of the US. And I was like, really? We can't think about this in a US context? And so that's right. The title of that poem is American State of Exception, because I was really thinking about what does the American state of exception look like? So this is Downs, the sort of highlights. So the question before the court, right, is a question that we still ask ourselves. And in fact, this is the same question that was before the court in 2016, right? What was Puerto Rico and who were Puerto Ricans to the US? So I'll kind of talk you through this, but these are some of the highlights. And I'll point out that Justice Brown, the Chief Justice at the time, wrote what we call a plurality opinion, which means that a majority of the justices agreed with the outcome, but they disagreed as to the legal why, right? So this case produced a lot of concurrences and dissents, right? Where people were disagreeing and agreeing with each other. And so in his plurality opinion, he sort of makes all of these pronouncements about territoriality and the Constitution, that when I was first reading this case, I was like, wow, like we never talk about race when we think about these cases, but race is all over these decisions, right? And the other little note is that this Supreme Court is the very same Supreme Court, same makeup that decided Plessy v. Ferguson just a few years before, right? So that's the sort of world that we're operating in. So the U.S. So what among the things that the decision stated, the U.S. Congress had the power granted to it by the Constitution to acquire territories, and it had acquired Puerto Rico legally with the signing of the Treaty of Paris. Okay, this did not mean, however, that Congress had made the territory a part of the U.S. or that the Constitution applied to the archipelago. The Constitution, and this is important, right? So here, the Constitution was created by the individual states of the U.S. for the people of the states of the U.S. And for only them, right, to be governed solely by representatives of the states. And so this decision is all about states, the people of the states. The constitutions are for the states, right? And Puerto Rico obviously was not a state. And the other sort of coin of this is that he says, nor were the people of the territories considered when the Constitution was written, right? So like, it wasn't for them because they weren't even an idea in the head of the drafters of the Constitution. So the Constitution didn't apply to them. And so the other thing that the sort of decision stands for is that, okay, Congress has plenary power, right? This was meant to sort of put to rest the idea that Congress might be a despot in the territories, right? Because there was this sort of counter argument that like we can't give Congress too much power because what if they act, as authoritarians basically in the territories? And so Justice Brown says, well, we're not saying that Congress has all the power. There are some restraints. The inhabitants of the territories are owed some rights, those rights that are sort of granted to everyone in natural law, natural rights. But they are not enumerated in this decision, right? So he doesn't say what those rights are, but he is decidedly clear that it's not the Bill of Rights and it's not the Constitution, right? Which in the US are the sacred sort of rights granting documents. And then he also says, listen, there are sort of inherent, there's an inherent restraint and basically a goodness to Congress that will sort of put a stop to them acting as a despot. We don't need to worry because there's a sort of inherent goodness in Anglo-Saxon principles of governance. Yeah, wow, right? Because this is being said by the same court that passed Plessy, and also, as we're about to see, by the successor courts that created Dred Scott and native dispossession, right? And basically had said in the past that Congress had all the power to do whatever it wanted. So that's kind of the decision, right? This is a part of the concurrence. So again, Justice White disagrees with the legal reasoning, but he agrees with the ultimate decision of the case. But so he says this, right? So this is the famous money quote from this. Whilst in an international sense, Puerto Rico was not a foreign country since it was subject to the sovereignty of the US and was owned by the United States, it was foreign to the United States in a domestic sense because the island had not been incorporated into the United States, but was merely appurtenant thereto as a possession. So these words really matter. Appurtenant matters, possession matters, sovereignty, domestic, right? Like these words are very purposeful, and they are actually pointing to other Supreme Court decisions and other that I write about in the book, but I won't go too deeply into this today because we could be here forever. But all to say that this concurrence, even though it wasn't the sort of main opinion, this actually becomes the justification for the doctrine of unincorporation, right? So over the next 20 years, what we see is the Supreme Court adopts this reasoning for the unincorporated territory. So ironically, it's not in the main opinion that the unincorporated territory is sort of created, it's in the concurrence. But by 1922, when the last of these insular cases are decided, this is the prevailing logic, that Puerto Rico wasn't incorporated and thus it was something else. Okay, so I'll leave it there and then I'll jump back. So I start the book with Downs, right? So I really struggled with this because I'm a historian and I'm like, doesn't it have to go in the order, like the timeline, right? And I was like, I can't have, and then I jump back in time, right? I'm starting with the Marshall trilogy, but I can't have a book about Puerto Rico that starts not with Puerto Rico, right? So the first chapter is like, this is Downs. And then the second chapter actually jumps back and says, well, let's talk about how we get Downs. So that's what we're gonna do now, which is, to talk about legacy, right? So how we get this is through this legacy of racial exclusion in the Supreme Court. So the early 19th century was a period of radical transition in the United States. As the growing population moved south and west from the northeastern region of the US, it became fractured. The question of sovereignty loomed over this period, animating disagreements about the powers granted to the states and those to the federal government. Against the backdrop of these intense debates in the first few decades of the 19th century, the US Supreme Court was also carving out a role for itself. And so that's important because I think we think of the Supreme Court as a settled entity, but in this period, there's a real fight between the federal government, the governments of the states, and the Supreme Court, right? And the Supreme Court is really trying to like carve out its power and say, no, this is what we're gonna do. And not all of the states agreed with the Supreme Court's power. So during this time of sectionalism, many in the southern states did not believe the court had the power to review their decisions, given that they were separate sovereigns. Their power struggle was most visible in two areas of wide import and consequence: the abolition of slavery and the so-called Indian problem. To be sure, the ignominious history of the US government's treatment of Native Americans and the enslaved is well documented. However, I would like to revisit several key Supreme Court decisions concerning the rights of Native Americans and enslaved Africans and their descendants and the events that led to them. These important precedents, which allowed for the dispossession of Native tribes, sanctioned the genocidal violence visited upon them, and subjugated enslaved and free Blacks, are essential to understanding the Downs decision and the court's approach to Puerto Rico. In focusing on the Marshall Trilogy, which was decided between 1823 and 1832, and Dred Scott v. Sanford, which was decided in 1856, we can see the birth and growth of plenary power and of the American state of exception. Native Americans and enslaved Africans were among the first non-white others the US legal system had to contend with, and the precedents established in these encounters have had lasting legacies that continue today. As white settlers moved into territories previously occupied by Native nations, the Indian question remained ever present. Namely, what was to be done with them? The imperative to civilize and to put land into productive use was one shared across sectors of the US population, but the matter of what to do with the Native peoples who resided on those lands remained unresolved. There was great disagreement about whether Native nations should be allowed to remain on their land, whether they should be forced to sell those lands to the government, whether the US should employ the military to forcibly eject Native Americans from desirable land. And the majority of opinions about what should be done were couched in the racist and paternalistic assumptions of the day, that Native Americans were either fierce warriors who had to be restrained or simple children who needed to be educated and trained. It is against this backdrop of debate and contention over where power should reside in the young US that the Marshall Trilogy was decided. Native American exclusion, like that of Puerto Rico, is premised on Congress's plenary power. By the time the US acquired Puerto Rico in 1898, the court had affirmed Congress's plenary power over Native Americans on multiple occasions. Importantly, the court had also established that Congress's actions over Native Americans and their territory were not subject to judicial review, and as a result, that power was nearly absolute and lay with Congress. Congress's plenary power over Native tribes was first established in a series of Supreme Court cases that began in 1823 and were known as the Marshall Trilogy because they were decided under the stewardship of Chief Justice John Marshall. The ideas and doctrines enumerated in the Marshall Trilogy form the bedrock of Indian law. In these decisions, the court rooted the power, this is a quote, rooted the power over Indian affairs and Indian lands firmly in the national government, providing fuel for westward expansion and its radical transformation of the US landscape. In these decisions, we see the Supreme Court and US government carving out legal lacunae in order to assert a nearly unrestrained power over Native tribes, while also limiting their rights and access to legal remedies. As law professor Maggie Blackhawk describes, these decisions quite literally allowed for the creation of reservations and camps where Native Americans were confined, neglected, and violated. Here we see the birth of America's state of exception, locations of Congress's unrestrained power, wherein residents are left with limited rights and few remedies. Plenary power has, and this is Maggie Blackhawk, been expanded beyond Indian country to justify seemingly limitless power over all kinds of people at the margins of American empire. This, we know, is the case in the US colonial rule over Puerto Rico and other insular territories. So I want to just very briefly, these cases are fascinating and not enough people who are not studying Indian law study them and read them. I will say that with the exception of this one, these two are brought by white claimants. No Native Americans participate in the cases, and yet the decisions are radically shaping Native American life. And so this is a land dispute. These two claimants basically orchestrate, and again, fascinating case, they orchestrate this whole legal case to go before the Supreme Court, like to the extent that like there's these big land companies, land trusts are trying to determine whether the US, whether whose claim to former Native land is valid, whether it's individuals or the US, right? So who can Native Americans sell their lands to? And they orchestrate this whole case. They handpick the defendant, they handpick the plaintiff, they handpick both sides of the law of the lawyers. They take it to the most favorable court in like the newly formed state of Indiana, like orchestrate it to a T. And then it goes all the way up to the Supreme Court, and the Supreme Court says, you don't win. Only the federal government, right? So Native American nations can only sell their land to the federal government. And so the key sort of the factors of this case that are like interesting for us is this idea of the law of the doctrine of discovery, right? So I like to, when I tell my students, it's like finders keepers, right? Like that's really what it is. And so where the Supreme Court finds the justification for Native Americans only being able to sell their lands to the federal government is in the doctrine of discovery, which says that the discovering party, in this case Britain, right, has the absolute right over Native American sovereignty, essentially. And the US, as the successor to Britain, then is that power. And Native Americans possessed sovereignty. It's really like what it breaks down to is usufruct rights. So they can use the land, but they can't sell the land, right? They don't have a full sovereign right to the land. And this is based in Congress's plenary power. This case was, Georgia was basically trying to do everything in its power to force the Cherokee Nation to leave their lands. And in doing so, they start to sort of basically regulate and pass laws that are sort of directly infringing on Native sovereign rights as a way of basically making it hard for them to be there or forcing the federal government to act. And so the Cherokee Nation sues Georgia for infringing on their basically treaty rights with the federal government. It says, you state of Georgia can't pass all these laws that are, they basically allow mining rights in Native and Cherokee Nation land and for white settlement, right? And they go to the Supreme Court and they say, listen, this case said that we are not a state, right? There are two types of plaintiffs that can go before the Supreme Court: states of the Union and foreign nations. We're not a state, so we must be a foreign nation. And so the whole dispute was really them asking for these laws to be found unconstitutional. But with every legal case before every single court, the court has first to decide whether it can hear a case, which is to say, do we, the members of this court, have jurisdiction over this case? And that's true at every level. So the Supreme Court says, well, first let's determine whether we have jurisdiction. And they say, we do not have jurisdiction because you aren't a foreign nation. You are a dependent domestic nation, which at the time, right, this isn't a designation that's in the Constitution. So it sort of meant that Native Americans were in this like limbo, right? Because if they're not states and they're not foreign nations, they're this, who can they turn to for recourse against Georgia and the other states? And so then shortly following this is this case, which was brought, Worcester was a missionary who was also a postal worker who goes to Cherokee country. And the state of Georgia at the time had a law that if you were white and you were going to go reside in Cherokee Nation, you had to have a license from the state. And Worcester was like, no, I'm a federal employee. So he goes to the Cherokee Nation and he's doing his work as a post officer and also as a missionary. And he's arrested and he's tried and he's found guilty and he's punished. I think he was sentenced to like, I don't know how many years of hard labor. And he sues. And of course, he's a US citizen suing a state. So this is properly before the court. And the court finds for Worcester. And they say, actually, you're right. Georgia is infringing. It's unconstitutional, right? And the US federal government has the sole rights to regulate Indian resources in Indian country. However, this is one of the many sad things of this case. The plaintiff is Worcester, not the Cherokee Nation, right? So the decision impacts only Worcester. So at that time, Georgia didn't participate in any of these proceedings. They were like, you don't have power over us, so we're not even going to go to the Supreme Court. But Worcester, because he's a missionary and a man of like, belief and faith, he then appeals. He goes to the sort of Council of Missionaries, and he says, what do I do? I've put up the good fight. I went all the way to the Supreme Court. This is what the Supreme Court says. And the council says to him, you have done basically God's work, right? You can now accept. So Georgia offered him a pardon if he would leave Cherokee Nation. And they're like, you can accept Georgia's pardon and leave Cherokee Nation. And the Cherokee must now accept that like all avenues are foreclosed, right? Like this is what the missionary council says. So essentially, even though this goes in favor of the Cherokee Nation, once Worcester accepts the pardon and leaves, the case is done, right? There's no like other recourse because the Cherokee aren't a party to this, even though it impacts them. So these cases, and again, they're fascinating. Please go read them. It's such an important part of our US history that people, I think because it's law, there's just people like, yeah, I don't know, fascinating. But together, these cases basically stand for the proposition that the federal government has plenary rights over Native Americans. And throughout the years, other cases have nuanced this, but this is still the case, right? It's still plenary power that Congress has over Native nations and Native lands. Okay, I took way too long on that. Moving way too slowly. Okay, so following the Marshall Trilogy, the court continues to grapple with the status of racial others within the US body politic, right? In 1856, in what has become to be known as one of the most disgraceful decisions of the US Supreme Court, Chief Justice Roger Taney, famously and infamously stated that Blacks, and this is the quote, had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and were so far inferior that they had no rights which the white man was bound to respect, and that the Negro must justly and lawfully, be reduced to slavery. So the court further explained that when the Constitution of the United States was created, it applied to all class of person who were recognized as citizens at the time of its creation, quote, but none other. It was formed by them and for them and their posterity, but for no one else. These pronouncements, of course, are part of the Supreme Court's infamous decision in Dred Scott v. Sanford and would later be echoed. So this was what I was hearing when I was reading Downs. I was like, what? This sounds like this, right? Later would be echoed in Downs v. Bidwell. And so it's interesting because there are some constructions of rhetoric, right, of like legal rhetoric within Downs that really, really like feel like they come straight from this, same as the Marshall Trilogy, right? So it's not just that they cite them for purposes of law is that they're using the same sort of legal rhetoric, legal construction. So what I do in these chapters is really close read these cases for that, right? For the like, what is the wording that they're using and why? The legal ramifications of Dred Scott would be overturned, of course, by the Civil War and the passage of the 14th and 13th Amendments to the Constitution, and then the Civil Rights Act of 1866. However, Taney's pronouncements in Dred Scott remain important today, not only as illustrative of the racial animus and hatred that underpinned the workings of US government, but also as illustrative of the continued development and deployment of the American state of exception. And this part is, to me, what's interesting, right? So we learn this case, if we learn it. I often ask my students, do you guys know who Dred Scott is? And a lot of them are like, no, and it makes me sad and it hurts my heart. But here we are, right? But what we know of this case is the part, right, that I just read, the part where Taney is like, African Americans are so inferior that they can be and should be reduced to slavery. But the other part, the part that was not overturned, right? So the 13th and 14th Amendments overturn enslavement and the sort of rightslessness of Black Americans. It doesn't overturn the territories discussion in this case, because beyond demonstrating Taney's clear hatred of Afro-descended individuals in the United States, it also was his attempt at saying definitively that Congress couldn't regulate slavery in the territories, right? So he goes, his purpose in taking this case, and again, this is another fascinating case, one in which the Supreme Court first decides that Scott is not a citizen of the US and had no right to sue. So by their own rules, this case should then stop, right? Because if he's not a citizen, he's not properly before the court, they don't have jurisdiction over him. That's all she wrote. That's how it usually goes. But Taney was hell-bent on talking about enslavement in the US, and he was hell-bent on taking the federal government to task for banning enslavement in the territories. And what he wanted was to declare the Missouri Compromise unconstitutional. So he goes into this whole discussion that we rarely talk about in our studies of it, about territoriality, about the operations of the US Constitution and the Bill of Rights in the territory. And what he says is Congress can acquire territory, but cannot hold it indefinitely as territory. Congress, it's a territory that's acquired by Congress must be put on a course to become states. The Bill of Rights, the Constitution apply completely in those spaces, and the people who reside there are citizens of the US, with all of the privileges and immunities, right, that every other citizen has. The idea is that territory will be territory until such time as it's ready to be states. And, you know, the underlying assumption is ready is when there's enough white settlement, right, for it to become a state. That stood, right, that was the sort of what we called the doctrine of territorial incorporation. That was the way that the US had moved like westward expansion, right? That's even how the US operates in Hawaii. Hawaii is acquired just very few weeks before Puerto Rico is, but it is acquired as incorporated territory. This is undone by Downs, right? So when we talked a minute ago about Downs' sort of proclamations about this unincorporated territory, this is why, right? This is what some legal historians call like the lion in the way of American imperialism was this decision, right? So the fact that the Supreme Court had enumerated quite clearly how territory functioned in the US becomes a problem in 1901 when now we have territory that's overseas and we don't want to incorporate it, right? We want to find a way to keep it, but we don't want to give everyone who lives there the Constitution, the Bill of Rights, citizenship. So that's where we get Downs. That's where we get the unincorporated territory. This is why, to my mind, you can't understand Puerto Rico without understanding this, right? And so I hadn't seen anyone do this. I was like, somebody's got to write it. I guess that's me because no one else has, right? But someone really has to make that connection very clear because, you know, it's an essential part of our American history, and Puerto Rico is often a sort of marginalized space. But I argue that it sits right in the center of how we understand the functionings of our government, right? And as an aside, I'll say that sort of making this analysis through law, I think, not that it makes it more visible, but to my mind, it makes it more sort of, it gives it some legitimacy, right? If I'm just saying this as a humanist without a JD, then people will be like, yeah. But if I'm like, no, look, this is the law, right? This is how we have written these laws and these decisions. And I have a JD, people take me more seriously, right? Unfortunately, that's the world we live in. So hopefully people will take me seriously. Okay, so that's the first half of the book. I lay out that argument in the first half of the book. And then in the second part of the book, I'm like, okay, now we've done that. Now we understand that. What has that meant for Puerto Rico? Has it been 45 minutes?
Yeah.
Okay.
About 34 minutes left.
Okay. So how long should I talk before? How much
Q&A?
How much Q&A do you guys want? Because I can go through this pretty quickly. I'll just go through the slides. I won't read. I'll just kind of talk this out. So what I do is the second half is kind of these 3 chapters that look at Puerto Rico in the 20th and 21st century. The first one is really thinking about this like first 3-4 decades of Puerto Rican history with the US, where Puerto Rico is quite literally remade, right? Where like the institutions of government are remade, industrialization happens in the kind of later portion of the 1940s. In this first few decades, land is consolidated pretty quickly under this kind of colonial capitalist order where sugar is given primacy as a kind of monocrop, right? And so this is facilitated by several hurricanes that hit Puerto Rico in the early 20th century and destroy the coffee corridor, which under Spain, coffee was the like preeminent crop, right? Export crop. So when these hurricanes come through and destroy that portion of the island or the archipelago, the US basically disinvests from coffee, sees it as an opportunity to instead invest in sugar production. And so you can see it's like, you know, these huge swaths of land are just become given over to sugar. And I argue that part of what that does is then determine where people live, right? Because if you once lived in the mountains and you grew coffee, and now coffee is no longer a viable crop, you're going to move to the coast where you and grow sugar, right? So it's sort of reframing every aspect of life, right? Not just the economics, but where people live and what they do, right? And also like where they're making family and community. So alongside of this is this sort of militarization and development of the Puerto Rico Insular Police, and really sort of making it a modern police force, right? It had been established under Spain, but it was sort of this like gendarmerie type, you know, with the US. They bring the US Army to Puerto Rico. They train the Insular Police. The police captain is appointed by the governor, who is appointed by the president of the US. And this was generally a man who had served in the military. The first sort of several police commissioners had served in the Spanish Cuban-American War, right? So they had that experience that they were coming from. And the police becomes, and this is something that I argued with Marisol Lebron in an article that we wrote a couple years ago, that this police force really becomes an instrument of the American colonial capitalist project, right? They are put in service of upholding colonial capitalism, which means that they are operating not for the benefit of Puerto Ricans, right, but for the benefit of industry and sugar in particular. They become a strike-breaking force, deployed often to ensure that labor labors where they are wanted to labor and how. And this comes to a head in the 1930s when, you know, in the kind of aftermath of the Great Depression, the global sugar prices collapse. And the US sort of disincentivizes the growing of sugar in Puerto Rico. There's also in the US at the same time is the kind of Midwestern beet sugar lobby is really lobbying for the US, for the federal government to privilege their sugar rather than Caribbean sugar, right? So, and all of this leads to this moment in Puerto Rico of like deep suffering where people are not making enough money to live, where they are, where like the sugar monopolies are sort of paying people in script, right? And folks are sort of recognizing that they're worse off in the 30s than they were in the 1890s under Spain. And there's these studies that come out, these American economists and American researchers come to Puerto Rico and they actually find that is true, that like the sort of quality of life has fallen so far below what it was in the 1890s, right? And people know this. And so they start to sort of ask, clamor, demand for some changes, right? In the 1930s in Puerto Rico is this period of like a lot of upheaval, many strikes, many strikes, massive strikes. And I call this period, this 1900, 1940s period, this kind of experimental station moment where the US is really trying to remake Puerto Rico in all of these ways through education policy, through health and hygiene policies, through economic policy, labor policy, right? And it is radically shifting where people live and how. And I argue that this is possible because of Downs, right? That we have this kind of opening for this experimentation and this remaking because the law doesn't function the way it does in the US, right? And people have fewer recourses to push back against this type of experimentation and remaking. So from there, then I go on to what is another pivotal moment, right? The creation of the Commonwealth of Puerto Rico in the 1950s. So in that 1930s upheaval moment leads us to this 1940s moment post, I'm sorry, what's the, I'm blanking on the like progressive Roosevelt initiatives. The New Deal, thank you. God, brain. So the New Deal, right? There's this kind of New Deal for Puerto Rico that is created right alongside as a parallel series of law called the Puerto Rico Reconstruction Administration, I think it's called, the RRA. And it's a New Deal for Puerto Rico, where an industrialization becomes primary. There are the similar sort of public works, right? Road building, infrastructure building, electrification, water, all of the kind of things that we associate with that New Deal era are also happening in Puerto Rico. And they're being administered first by, he is the last appointed governor of Puerto Rico, US appointed governor of Puerto Rico, or mainland US appointed governor. So he, after him is a Puerto Rican who was appointed by the president. And then in 1948, we get the first sort of Puerto Rican who is elected by Puerto Ricans. But all of them are part of the same party, the Popular Democratic Party, who are sort of ushering in these progressive policies and this sort of changes in Puerto Rico. And they are usher in the Commonwealth of Puerto Rico. So for me, that moment it's important because of the kind of way it reshapes Puerto Rican society with industrialization, with people moving out of rural areas into the cities and into the creation of suburbs, really. And with the like beginnings of the massive migrations of Puerto Ricans out of Puerto Rico to the US mainland, to places like Chicago and New York and Philadelphia. All of this is happening at once. And it's sort of the project is being led by this Munoz that Rexford Tugwell refers to, who they actually work together. Luis Munoz Marin, first democratically elected governor of Puerto Rico. So he is part of this like brain trust of men, mostly men, that orchestrate this and create the Estado Libre Asociado, the Commonwealth of Puerto Rico. And the possibility of the Estado Libre Asociado happens in this moment post-World War II, right? When sort of decolonization is in the air, right? And the Cold War is starting and the USSR is in ascendance, right? And the US is sort of interested in taking up the mantle of being the global leader of the free world, right? And so in that context, it makes a lot of sense that having a colony doesn't look good, right? And so the US is in this sort of open moment of, okay, we can consider something else. And what is born is the Estado Libre Asociado, which creates this public law 600, eventually becomes the Constitution of Puerto Rico. It creates a constitution for Puerto Rico. It allows for a local government, creates a local government that will be democratically elected by the people of Puerto Rico at every level. So Senate, House, the governor is appointed, and it is sort of billed to the people of Puerto Rico as local sovereignty or local autonomy or self-determination in the parlance of the day, right? This is the moment of, we're talking about self-determination in the international arena. But at the same time that they're saying this to the public, they're saying this, right, to Congress. So Antonio Fernos is part of this brain trust. He says to Congress in the debates, so all of this has to be approved by Congress, right? Congress has to approve the Constitution of Puerto Rico. They have to approve all of this maneuvering. It cannot happen because Puerto Rico desires it. It has to also be Congress that says, all right, we're going to let you do it. And so when they're sort of arguing before Congress, let us do this. This is what we want to put in our Constitution. This is what, we're ready to be self-determined. They are also saying to Congress, Public Law 600, right? This is the Constitution of the US, of Puerto Rico, would not change the status of the island relative to the United States. It would not alter the powers of sovereignty acquired by the United States under the terms of the Treaty of Paris. Luis Muñoz Marin that also says to the House, if the people of Puerto Rico should go crazy, Congress can always get around and legislate again, i.e. restrain us, right? I am confident that Puerto Ricans will not do that, i.e. go crazy, and invite congressional legislation that would take back something that was given to the people of Puerto Rico as good American citizens. This rhetoric is so repetitive, right? We are always talking about Puerto Ricans being good American citizens who are worthy of X, Y, and Z, as recently as this past election. So I'm reading this thinking like, what did the Ella then actually do, right? And so again, I put on my legal brain and I think, well, nothing, because we talked about Downs v. Bidwell, and that didn't change because of this. So the structures underpinning the creation of the Commonwealth of Puerto Rico remained. We built this layer, right, on top of it of sort of local autonomy, but what it sits on is still Congress's plenary power, right? So this is my thinking. And then 2016 happens. And so I talked a little bit about this case at the beginning, right? This is where Ruth Bader Ginsburg is like, but what? And so this case was about bankruptcy. This is the Puerto Rico's government attempt to pass its own bankruptcy law to address the debt crisis. And Franklin California Tax-Free Trust et al. Are the banks that own the debt, right? That sued Puerto Rico, and we're like, no, you can't create your own bankruptcy law. Federal law preempts you from doing that because states can't do that, right? So the federal law, tax law, nebulous as you might imagine, but in the context of Puerto Rico, it says Puerto Rico is not a state. Well, I'm sorry, it's not Puerto Rico v. Puerto Rico. It's Puerto Rico v. Franklin California Tax-Free Trust et al. It says Puerto Rico is not a state, is to be considered a state for the prohibition against passing its own bankruptcy laws. But it's not a state for this other part of the law, which allows states, not Puerto Rico, states, to designate an entity a debtor. So this is why that poem earlier said, you have not been designated as a debtor. So I always use the example of Detroit, right? So when Detroit was in its debt crisis, Michigan couldn't write a law that says Detroit, you can go to bankruptcy, but it can say, Detroit, and this is a legal term of art, you are a debtor, go access federal bankruptcy. And that's what it did. That doesn't apply to Puerto Rico. So the relief of being designated a debtor didn't apply to Puerto Rico. This is why Ruth Bader Ginsburg says, what is this Never Never Land? Can't use a Puerto Rico solution, can't access federal bankruptcy. You have completely bound this entity. So days before that, though, this case, which I think is so interesting, this is a double jeopardy case, right? So this guy, Sanchez Valle, was selling guns in Puerto Rico. And he was arrested and tried and charged under Puerto Rico laws that prohibit gun trafficking. Okay. The federal government then brings charges for the same exact thing. And this guy pleads guilty to the federal charges and gets house arrest or something. And then he moves to have the Puerto Rico charges dismissed. He's like, well, okay, I've pled guilty, double jeopardy. You can't try me for this, Puerto Rico. Puerto Rico says, no, actually, we're a separate sovereign. The Constitution says you can be tried for the same thing if two separate sovereigns try you. So federal government and state of Texas, for example, right? That can happen. And so Puerto Rico goes all the way up to the Supreme Court and says, we are a sovereign. We should be able to try this guy for these crimes. And the Supreme Court here says, and I quote, Elena Kagan writes, sovereignty here does not bear its ordinary meaning, which to me is so beautifully encapsulates everything about Puerto Rico, right? Because nothing means what it should in Puerto Rico. Instead, the Constitution of Puerto Rico, from which the government of Puerto Rico gets the power to prosecute criminals, right, is a delegation of Congress's plenary power. It is not inherent sovereign power because Puerto Rico is not a sovereign. It is, in fact, a designation of Congress's plenary power. Thus, Congress gave Puerto Rico the right, and it can take it back. But it also means that the power to prosecute emanates from Congress and not Puerto Rico, right? So double jeopardy did attach because it would be the same source of power prosecuting this guy. That to me is fascinating, right? But this is what I'm saying. The 2016, I'm like, well, then we're right back to 1901. And all of this intermittent history and the creation of the Commonwealth really didn't mean much, right? Because if the ultimate source of the power to do any basic governmental function is Congress, then Puerto Rico doesn't have any autonomy to decide itself, right? And what we see over the kind of intervening period is Congress has sort of chipped away at the local power. But the 2016 moment, and then of course, Promesas passed days after, and all of those things together are this like, aha, the veil has been lifted. We understand, right? Colonialism 2.0, 3.0, whatever you want to call it, is just 1.0. It never left us, right? So anyways, I talked a lot, I'm sorry. But that's what the book says, right? That we are, that 1901's foreign in a domestic sense is 2016's Puerto Rico and Never Never Land. That didn't change. And so my point in the book is that I really wanted to make this very clear and trace those threads, right? Because people had a sense, especially when Promesa was passed and the fiscal control board that was put into place to govern Puerto Rico's affairs. This all seemed very like, oh, we are right back to where we started, right? But there was still a sort of a populace in Puerto Rico that had this notion that like, well, no, things changed. The L meant something, right? And I really was like, well, let's look at what it did, right? Let's pull out those threads. And that is what the book does. So thank you. A little bit longer than I wanted to, but I appreciate your patience. And I'm happy to answer questions forever, however long we have. Thank you.
So, I mean, I feel like working in Latin America and Puerto Rico is a kind of relationship between the two. And I always feel that, but seeing when you lay out the way that the law is used to source the kind of ongoing racial possession is so fascinating. And I guess what I would love to talk more about, and what you're talking about in the book, is just like there is this tendency to treat Puerto Rico as though it's kind of like marginal political geography and then like marginal political states. But seeing access to those figures into capturing their complications of policy and shaping their sort of legal understandings of things like citizenship and territory. I had no idea. So I wonder if you can kind of talk about what it means to kind of bring Puerto Rico into the conversation, not in a way that's about saying like, oh, Puerto Rico matters too, won't you pay attention to us? But instead it's really about thinking about how Puerto Rico as a political territory figures centrally in U.S. conceptions of foundational political concepts of how the state.
Yeah. Thank you. And I think that's always been, when I first started this project and when I was a grad student, certainly, and, I don't know, Michael, maybe this is your experience as well. I felt like every talk, every sort of invitation always came with like a little bit of okay, now I have to explain to you why you should look at this and care, right? And unfortunately, the sort of debt crisis and Hurricane Maria has made Puerto Rico so visible to people, right? And so relevant, right? I'm grateful that it's relevant and urgent and necessary. I hate why it's so necessary and right, why it's visible now, why people care. But it's made that sort of me not having to give the preface anymore, right? I don't have to explain to people why we should look at it because we're looking at it. So that's an opportunity I see to say, okay, now that we are looking at it, let's look at it from these lenses, right? which is to say Puerto Rico is, often invisible unless it needs to be visible for, a primary, or it's visible because it's been in crisis, right, in a hurricane. But in fact, the workings of its relationship with the US are so sort of part and parcel to the way that the US operates, right? And so it's not, we always think of it as an exceptional space. And it's exceptional in that, it's still a colony, right? We still it still bears that title in the official way that we understand that title to mean something, right? Those of us, probably all of us in this room, study colonialism and in its many manifestations, right? And instantations. And we know well that colonialism looks many different ways and is still very much with us, right? But for a sort of general public that is like, oh, wow, okay, Puerto Rico's still a colony, right? I think it's important to then be able to say, and this is how we have made this, right? And the logics that created it sit very centrally to the way that we function as a state, right? As a government. I was doing this talk this weekend with he's a journalist and historian of immigration. And I was telling Michael this. His argument was about this kind of redemptive narrative of American possibility, right? And the kind of American dream narrative that, many, at least in the past, I think maybe many immigrants bought into, right? I think most immigrants now know very well that is not going to be that, but that this is still something worth endeavoring. But at some point I had to just be like, listen, I want us to complicate what we're talking about, right? Because the US has never been a friendly, he was making this argument about we have to go back to when the US was friendly to immigrants. I was like, I don't know when that is. That was never, right? That's not the history I know. And I want us to really think about the ways that these moments are not exceptional, right? This is not an aberration, this moment of hatred towards immigrants or, talking about Puerto Rico as a floating island of garbage, right? None of that is exceptional. That is part of the essential sort of American narrative. And I think if we understand that and we sort of disabuse ourselves of the notion that this is somehow outside of the norm, then we can really deal with, okay, this is what it is and what it has been. How do we then confront that, right? And of course, that's dangerous, right? That's very dangerous. I live and teach in Texas. I am very aware of how dangerous these histories are, right? But they're so necessary. Yeah, so I don't know if I answered your question. I feel like I went on a tangent, but I tried. Other questions, thoughts, comments? Yes.
Yeah, I have a comment and also it's just a thank you. I think that so many of us, or I'll speak for myself, I work with a lot of analysis of very contemporary administrative data and health survey data for Puerto Rico, and I try to link it to I try to frame these as consequences of promesa and this disinvestment from so many essential services in Puerto Rico. And I think, something I've definitely experienced, I'm a postdoc now, but, so recently in grad school, and even at times, since grad school, I think that especially when you're not in a room full of people that are studying these things and are thinking about this, there's so much, there still feels like such an argument. It feels like I'm often making the argument just for the existence of colonialism as still a way of understanding what's the lack of sovereignty there, right? Mm-hmm. And this, you laying it out this way feels like it does such a, I feel like I have the paragraphs in my mind that I've written into articles about oh, this happened and this is why it makes sense to think about these as colonialism and understand these as consequences of it. But I just feel like you did it so clearly there, and this is exactly the book that I want to cite in those paragraphs. Thank you. Yes, please cite the book.
Thank you for that. I think that I'm going to tell a brief anecdote that I think sort of speaks to what you're talking about. When I was a grad student at UT, we had it was a job talk. He's now working at UT, very prominent scholar. I won't give his name because he is one of these famous historians. But he came and he gave a talk all about diplomatic historian, right? So historian of the US and the world.
Now we can find
Probably. But I mean, I'm going to describe what he was talking about in that, and it will be very easy to find because he was publishing at the time. And, you know, I don't want to date myself, but this was a while ago. He was publishing about how the US's sort of various military operations in the world were never about occupation. They were always about democracy building. Democracy building is the buzzword phrase that will take you exactly to who this person is. But anyways, this was also the time when certain universities in the Midwest were sort of undue tenure, and there was sort of like a raucousness happening. And so he was leaving his institution, trying to come to UT. And so he's giving this talk where he's talking about these various military interventions that the US, you know, navigated in the 20th century and how they're not, they're all about democracy building and not about, you know, colonialism or expansion, whatever. Gives his whole talk, blah, blah, blah. I raise my hand very meekly. What about Puerto Rico? Oh, well, Puerto Rico, you know, it's an aberration. Like, basically, his whole thing was like, bracket, Puerto Rico, I don't want to talk about it, right? And so I'm a grad student, so I was like kind of pushing back. And he's like, yeah, you know, one of my colleagues is always pushing me on this too. And I'm like, and right, but it was that moment where I was like, I cannot believe you are preeminent scholar and your solution is bracket that, not going to discuss it, right, when this throws a wrench in absolutely everything that you're saying, right? And so I hear you, right? Like, there's all these ways in which if we really want to understand, right, all of the kind of complicated web, you have to look at Puerto Rico and deal with its complexity, right? Not just be like, oh, it's this like, you know, frozen and amber thing out there that really isn't consequential. It's like, no, it actually is very consequential to understanding the operations of US military intervention, colonialism, however you want to call it, right? I remember I was in grad school too at the time, in law school and then grad school at the time of the kind of war in Iraq aftermath, right? With like Guantanamo becoming ascendant again and all of these black sites where people were just being disappeared into, right? And so this question of sovereignty and the US's sort of possession of these nebulous places where they held control but disclaimed sovereignty, right? That was really important. And the way they were doing it was through Puerto Rico. They were looking at these insular cases. They were looking at the ways that US empire in the early 20th century had created these overseas territorial spaces to then create, right, to justify the torture memo, all of that stuff, that looks at these cases. And I was like, how are we not talking about this, right? So for me, it was like, yeah, of course, we're still very much at the center of this like discussion, even if people want to be like bracket it, doesn't matter.
Yeah, I want to thank you so much for a wonderful book and the talk. I am Tabula Rasa in the case of Puerto Rico. I think I'm also the result of the epistemological violence that when we study about the US, etc. I'm myself Palestinian, and how we can relate to this book in other contexts. And you know, the same sentence you said now about democracy, the US diplomacy, and the bracketing of colonialism there. I have been discussing with Israeli scholars that argue that Israel is a democratic state, while asking them about how about leave now the issue of the citizenship of Palestinians in Israel.
Right.
Talk about the occupation of the 1967 Palestinian territories. There are territories there, and Israel is running their life. There is no Israeli official sovereignty there, right? But it's a colonial case. So this case of the bracketing of the colonial empire aspects and dealing internally as if the United States or Israel is a democracy, and etc. Even without talking about the history of the inception of the state of Israel.
Right.
Taking your book, it's really, when I knew about this talk, I immediately penciled down the talk because I wanted to learn, and I think the connectedness between these cases
Deeply connected.
This way
Deeply
we can
connected.
organize our epistemology, right? So thank you. I really learned a lot. I'm looking forward to
Thank
read the book.
you. Thank you for that comment. And I agree that those histories are deeply connected, right? And that there are deep, deep overlaps in the ways that this is understood. And as you were talking, I was thinking about the fiction, and in Puerto Rico, I know how this fiction is created in Puerto Rico, right? The fiction that Puerto Rico is not a colony. There is a concerted project of the state to sort of say, no, the Commonwealth of Puerto Rico means we can have the best of both worlds, right? We're not a colony of the US, we have local governance, but we have a really unique connection to the US, right? Like, isn't this great? And in part, that's why I wrote the book, right? Because I want to be like, no, let's lay it bare. But those fictions, right, that really obfuscate the possibility of the conversations that become so powerful and entrenched, and which is why these sort of histories then are so sort of reviled, right? Is because
one thing that you mentioned that was really for me looking at the same processes that, as if I'm looking at the legal processes in Israel, and one of the things that I really am thinking with you about the legalization of the colonial. Why it was important for these courts to legalize the processes of colonialism. And the same thing is in Israel-Palestine. Like, you can just change some of the years, and some of them are really the same years, 1948 and etc. But changing the names, the court decision, that etc. The legalization of the colonialism is. It's something that is fascinating to look about. And even without like me studying Puerto Rico, but I think this book is very crucial for someone who's studying colonialism or legal colonialism.
Legal colonialism, yeah, for sure. Thank you for that. Yeah, my aim in writing the book and in writing it in the way that I wrote it to is that it can, I hope, speak across a lot of different modes of thinking, right? I won't say disciplines because I don't want this book to be about to sit in the academy, right? I want people to read this book, and I want people who are thinking about Palestine to read this book, and I want people who are thinking about the Pacific, right? The U.S. colonies in the Pacific, and the way that the U.S. is sort of remaking the Pacific, right? I want those conversations across spectrum, right? And I think that, I don't want to tout my own horn, but is what I wanted the book to do, right? And I hope that it will do. I don't know if it's doing it yet, but I hope that people will come to the book and see the connections that you're making. So thank you so much for highlighting that. I appreciate it.
It's out of time, but if you have one more comments or questions. Join me in thanking one time.
Thank you all so much for the time and the attention. I really appreciate it.
Here's some folks.